right, welcome back to another PSI Real Estate Exam Prep. Today we're going to talk about the state of Colorado. So this is going to be state specific. And in today's PSI Real Estate Exam Prep, we're going to cover Colorado forms and contracts, which is 23 items on the exam, brokerage relationships, which is 11 items on the exam, and activities of licensees, which is another 11 items on the exam. And so if you're keeping score at home, this is 45 pieces of content out of the 74 pieces of content that you're going to be expected to know. And so this is the good majority of your quiz. And as we're going through this, if you're getting a very good understanding around this and you feel comfortable, firstly, this is going to translate over to a lot of the other questions, and it's going to make things a lot simpler. So let's start off with Colorado forms and contracts, 23 items again. If we're going through listings, contracts, and buyer representation agreements, very firstly, we have the exclusive right to sell listing, which is an agreement between the homeowner and the real estate agent, granting the brokerage the exclusive authority over the transaction. This is a legally binding contract that ensures that the agent will get their commission upon the sale of the home. So this has the most protections for the agent. So regardless of how the sale comes to fruition, the brokerage gets paid. On the other hand, we have the exclusive agency listing, where the homeowner says that this is the only agent or brokerage that can help sell the property. Now, if the seller goes and procures the buyer on their own, then the agency will not get paid. Now, another brokerage can't step into place here. And if they're on like the front porch having a conversation, someone walks up and says, "Hey, I'm interested in buying your house," and you weren't a part of this deal, they do not have to pay you. So in the exclusive agency listing, you must be the procuring cause to get paid. Exclusive right, most protections. Exclusive agency must be the procuring cause. Now, on the same side, we have the exclusive buyer agency agreement, which is the exact same thing as the sell side. In this agreement, it is legally binding. You're the only agent that's allowed to help. And if your client goes and walks into an open house and signs any paperwork, you still get paid. So this is the most protections on the buy side for the agent. Now, under the exclusive agency buyer agency agreement, and you can see this as agency twice, that is your tell for this one must be the procuring cause. Same scenario, your client walks into an open house, they sign on the dotted line, you are not a part of helping them find this property, you do not get paid. So you must be the procuring cause on the exclusive agency buyer agency agreement. And on the exclusive buyer agency agreement, it has the most protections for the agent. Now, when we talk about the Colorado contract to buy and sell, right, this is when you are purchasing a pre-owned home. Like, this is the contract that you're going to use, because we know the builders use their own contracts. They don't have to use a Colorado Real Estate Commission approved form. And so in Colorado, we know that the CREC has all the contracts that we use as real estate agents. And because of Conway Bogue, like, this is the only contract that we are allowed to use on a traditional real estate deal on most pre-owned homes. The parties to this contract are the buyer and the seller. So when we get a question around this, the parties to the contract to buy and sell are the buyer and the seller. We also know that the broker has the authority to complete standard approved forms, right? And in the state of Colorado, you know that if the form exists, that's the form that we must use. All right. And we have to be familiar with what form makes sense for what transaction. And we know that we are not allowed to create our own documents. And again, if the form is in existence, we must use it. And the reason for this, again, is Conway Bogue, right? Conway Bogue gave us the ability to practice limited law in Colorado. So if you get a test question around, what court case, it was Conway Bogue. And there it is. A piece of this as well with the standard approved form is this. The printed portion of this form, except differentiated editions, have been approved by the Colorado Real Estate Commission, right? This is right out of the contract. And every contract that we have actually states this on there. You're also going to know deeds of trust versus promissory notes. And so a deed of trust is a legal document that is establishing a voluntary lien on real estate. It says the grantor, who is the property owner, transfers the property as collateral to a beneficiary, who is typically the lender. And it says additional, the public trustee assumes the role of the deed in trust, possessing specific powers related to foreclosure. So we're going through here, we know that we're the grantor, we're also the mortgagor, and then the bank is the grantee and also the mortgagee, right? So the bank is the beneficiary, right? So we're going through here, that's a deed of trust, that's a legal document that's putting a lien on the property. But then we also have this promissory note. And what this says this, hey, lender, if I don't repay, right, you can go through and foreclose on my house, but this is my promissory note stating that I am committed to repaying. And so the deed of trust is actually putting the lien on the property. And then there's a promissory note that's actually going through, and it's just the promise to repay. All right. So promissory, promise to repay, deed of trust is actually the voluntary lien. In Colorado, we have non-judicial foreclosures. And so, if we were to go through and we were to default on this and the bank wants to foreclose on the property, they don't have to file a lawsuit. They just need to actually present the evidence to the judge, right? And they're going to show the promissory note, the deed of trust, that you missed payments, and that they are going to take the property from you and go into the foreclosure process. Disclosure documents, right? So a couple things that we need to know in here. Firstly, let's talk about this federal law around homes built on or before January 1st, 1978. Yes, lead-based paint. And it says an EPA approved form. It's a pamphlet that has to go out to the home buyer. And it's called Protect Your Family from Lead in Your Home. Like, this is a form that we have to give, this pamphlet we have to give to every buyer. Any known information concerning the presence of lead-based paint or lead-based paint hazards in the home. Like, we have to make sure that we're disclosing any of that. And there has to be a lead-based paint disclosure that includes a lead warning statement that just says, like, hey, do we know if there's lead in the house? And if we did know that there was lead in the house, did we do anything about it? Like, that's all this is. It's just a disclosure. This is a big thing, right? Penalties for failure to comply with federal lead-based paint disclosure laws include up to 3 times the damages, attorney's fees, costs, and a base penalty up to $11,000. So we're talking like $16,000 penalty if you fail to give this lead-based paint disclosure, and the contract's void. And so, guys, this is a legal component of the contract. So if you do not have a lead-based paint disclosure attached to a property built before or on January 1st, 1978, you have a void contract. Not voidable. This thing is void. Plus, there are huge penalties for failing to provide this form. Now, as we're going into disclosure documents, the seller's property disclosure. And it says, on or before the seller's property disclosure deadline, the seller agrees to deliver the buyer the most current version to the seller's actual and current knowledge. All right. So this means that, like, if we discovered something after we completed this thing like 5 days ago, we have to update it. And what this also means is, like, do you actually know this information? If you don't actually know it, we're not asking you to assume what's behind the wall or what's under the carpet or below the floorboards. But if you know that there is an issue, you must disclose it. And again, this is the seller. The broker should never fill out this form. You are never to fill out this form. And you must know that if you know any adverse material fact, like you are obligated to disclose, even if it hurts your seller, even if it hurts you, and even if it hurts both of you, you must disclose any information. And again, here you go. Here's actually a piece of the contract that we pulled out, seller's property disclosure. You can see this, that it's not mandatory, right? Does the seller agree or not to agree? Do they not agree to providing this seller's property disclosure, or do they agree? And with that, again, even if they don't agree and they say, you know, I never lived in this property, they still know stuff about the property, right? So this is an out-of-state investor. Who do you think the landlord's calling or the property manager is calling if there's an issue? Well, they're calling the homeowner, right? So if you have an out-of-state investor, it's like, well, I never lived in that property. Well, they still got all the bills for any maintenance that had to go on. So they do know something. They don't need to provide a seller's property disclosure, but they do need to disclose any adverse material facts actually known. Then we have a thing called an addendum, right? The addenda to a contract, and you're going to need to know what this is. And so an addenda or addendum is what goes through and it introduces new elements into the original contract. All right. So this isn't like a small deviation from a contract, like where I'm changing a date, right? The date already existed and I'm changing it. That's called an amendment, right? So when I amend a contract, I actually have it in the contract and I'm just changing it in the contract. Was never in the contract. So maybe the seller and the buyer intended for the appliances to be in the contract. And when they were going through, they left it out of the contract to buy and sell. But the seller doesn't want to deal with having to have a yard sale and getting rid of all the kitchen appliances. And the buyer really wants them. And they intended from the beginning to do it. Well, they would do an addendum and they would add that personal property back into the contract, right? Maybe it's the refrigerator, the oven, like they just missed it in the beginning and they want it to be there. That is a change to the contract. That is an addendum or an addenda. We also have to know what a counterproposal form is, right? And so here's a snapshot of it. And what it does is it really just goes through and it is a response to the original offer where something's rejected or replaced, right? So maybe I want to change the dollar amount, or maybe I want to change a date. This is where I go through and I do this. When you're going through, you have the option, right? The person receiving the counter offer, they can accept it, they can reject it, or they can actually make another counter offer, and we just continue back and forth in the negotiations. Neither party is obligated to the contract until they both sign, right? Then we have offer and acceptance. Typically, the buyer is always the offerer, and the seller is always the offeree, unless they're countering. Then whoever counters is the offerer, and the one receiving the counter is the offeree, and this thing can go back and forth as many times until someone signs it. The old offer is no longer in existence. So the offer before the counter is void at that point. All right, it's gone. It is off the table. This is a brand new offer every time. Then what we have is called closing instructions. And the closing instructions serve to engage the closing company with the parties of the real estate transaction, right? So this is the buyer and the seller. This is what the closing company is going to do, right? You can see the deed, the bill of sale, the closing statement, the title and commitment. Like this is everything that the closing company is going to help. I like to think of this as like the playground rules. This is what the closing company is going to help get to the finish line and all the things that they're going to help to do to make sure paperwork is properly done. That's closing instruction. So now let's look through this and let's talk about brokerage relationships. There's 11 items on your exam. And so when we start talking about the brokerage relationship disclosure, the definitions of working relationships form, firstly, is not a disclosure. All right. It is just a form that is required. And when we go through, all it is letting the other party know what relationships can be held, right? That's all this thing is. And it's like, awesome, I'm representing the seller, so I have to treat you as a customer. And we know that this thing must be in writing. It must be made to the consumer as early and as in a reasonable opportunity before you start getting some confidential information. Like if someone walks in off the street and they tell you, oh my God, like I would love to buy this house and I need to because I'm about to get evicted and I have to, I'd be willing to pay $100,000 over asking. Well, if you work for the seller, you have to give all that information. So you have to be like, whoa, 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 pump the brakes, land the plane. Anything that you say can and will be used against you because I must report this to the seller. I have a fiduciary responsibility to help them win and get the most amount of money for their home. So we have to make sure that before they give us any motivation, we get this brokerage disclosure in front of them. And this is the thing. If they don't sign it, we also have to go through and actually just wrote like would not sign and like give them a copy of it and keep a copy for ourselves. As we're going through again, another thing that we have to keep in mind is if we are changing from agency status with two different parties and we're going down to transaction broker, it's called a change of status. This form must be presented at the time that the broker begins to assist both consumers. All right. So if you work for the seller and you work for the buyer and both of them want to, be on the same property and you're an agent for both, and then like the stars align and they're like, yeah, you can become a transaction broker for both of us, then you have to present the commission approved, right? CREC commission approved form for a change of status, which drops you down from an agency down to a transaction brokerage status for both parties. So transaction broker, right? So as we're thinking about a transaction broker, you don't work for either party. All right. You don't work for the seller. You don't work for the buyer. You work for the transaction. All right. You're like an assistant. You are providing some support and some guidance. You're not advocating for either party. You're not doing anything to give the other party a leg up. All you're doing is presenting. Like someone tells you to do something and you present, or hey, the date deadline's about to come up. That's what a transaction broker does. Keep in mind that if in Colorado you don't have a written agency agreement, then you are a transaction broker by default. And again, think about this. You're Swiss, right? You're Switzerland. You are neutral to both parties. Now, single agent, right? This is something that you're going to need to know. And this means that you represent either the buyer or the seller. You can't work for both simultaneously, right? Especially in Colorado. That's called dual agency, and that is illegal. Now, if you're working for the transaction and you're not representing the buyer, you're not representing the seller, that's transaction brokerage. And if you work for one party, you work for either the buyer or the seller, that is agency. All right. And we do not have dual agency in Colorado. Again, that is illegal. In Colorado, you're going to be a designated broker. And what that means is that you're the person that's assigned by the employing broker to act as a single agent or a transaction broker to the seller, a landlord, a buyer, a tenant during their real estate transaction. And so you can see here, right, this comes out of the Colorado contract, the agency agreement, and is saying, do you work for a multiple person firm? And you are the person that the broker has designated as the designated broker. And you can see that this relationship does not extend to anybody else except for to you. So this means that it's perfectly legal for someone else inside of your brokerage to represent the other party. It means also that the employing broker can help you and to assist you because this relationship doesn't extend to them, and they could be representing another party during the same time. One person firm, a little bit different, but a designated broker means that the employing broker designated you to help out this party, and that if anything is going through with another party in your brokerage, that is perfectly legal if they represent the other side to this thing, because the agency agreement only extends to you, the designated broker. So let's talk about requirements governing the activities of a licensee. And there's 11 items of this on your exam. So an employing broker must adopt a written office policy which identifies and describes the relationships in which the employing broker or any associate may engage with consumers, right? Can I help them as a transaction broker? Can I help them as an agent? Can I help them as a customer, right? Like it breaks down stuff like this for the relationships. Every independent broker, employing broker must reside in Colorado that has a place of business. All right. So there must be a physical place for the commission to go knock on the door and to go review files for compliance pieces. So every employing broker in Colorado must maintain a physical address. And it says workers are considered employees in a company if the company withholds their taxes, their Medicare, and their Social Security. The company also has full control over the work and how they do it. And so, guys, this is brokerage administration. Like you're going to become an associate broker in Colorado. And so you're going to have some basic understanding of how all of these things work. And there's a lot of different moving pieces around this. Again, there's only 11 questions, and we don't know what the 11 questions look like. So that's why we're throwing some pieces at you. Commissions, rebates, referrals, and fees, inducements from settlement services. So firstly, we just got to keep in mind commissions charged by the brokerage firm are not set by law. They are established by each real estate brokerage firm, right? So the brokerage firm says what your minimum is, and when we go through and we have our minimum that the broker says we're allowed to charge, it's still a negotiation between you and your client. Now, the brokerage firm says you can't accept anything less than this, then you might not be able to work with the client. The client could be like, okay, cool, like I'm going to go find someone that will allow me to work with them at this price, and it's still a negotiation. Only brokerage firms licensed in Colorado are permitted to receive commission on transaction fees or for real estate located in Colorado. So what this means is that I can give a split of my commission to another real estate agent that has a license in the state of Colorado. Also, if they have a license in any other state, I can also give a piece of my commission as long as they were somehow a part of this transaction, right? Like if someone gives me, hey, Charles, I live in California and I have a client that lives in Colorado that is looking to buy. If I give you their name and phone number and you're able to help them, would you give me a 30% referral fee? Well, absolutely. And that's what this is talking about. So you can give commissions, right? Splits of your commissions to someone as long as they have a real estate license. And it says prior to or at the time of contract to buy and sell that is executed, we have to disclose any affiliated business arrangements that the brokerage or the broker may have in writing to all parties to the transaction. All right. So, like if I am a part owner in a title company and I need to make sure that everyone knows that I am going to make money off of that title company if we use them, right? Or if a client, right, is going through, we just have to make sure that they know because of RESPA, we need to make sure that they know that there is money that I'm going to benefit on based off of my recommendations. Disclosure of conflicts of interest of or license status. So first and foremost, you have a fiduciary obligation to each of your clients, and you have to put their interest first. All right. So if there is a conflicting interest, like maybe you're helping a client and it's your family member on the other side. Well, firstly, shame on you and your family member for not working together. And with that being said, you have to make sure that your client knows that, hey, there's a conflict of interest here. Like I represent this and I am this person's friend or family member or whatever. And I don't know if I can be completely unbiased. The second thing, right, says license status. If you are looking to purchase or be a part of some kind of rental transaction, you have an unfair advantage compared to the rest of the public. You must let them know that you are a licensed real estate agent. Like that must be disclosed. So again, these are the two things. These are disclosure. If you're a licensed real estate agent and you're looking to buy a piece of property, you must, or you're selling a piece of property, you must disclose that. And if there's a conflict of interest, you're supposed to put your client first. So you must disclose to them like, hey, this is what's going on. Handling of documents. So as we know that we have to have documents for 4 years. All right. We have to hold all documents for 4 years. And so if anything pops up, that's why we have to be a licensed and addressed in Colorado. And so if the commission needs to go review anything, they can go back 4 years to that address and go look at the stuff. If a broker has a brokerage relationship with a consumer in a transaction, the broker must review closing documents and attend the closing or be reasonably available. And if you can't be there, the brokerage or you can have someone else step into the closing. And guess what? Everyone is responsible now. The managing broker is responsible for accuracy, completeness, and delivery. You are, if you're on a beach in Cabo, you're responsible for accuracy, completeness, and delivery. And the person that sat in for you is also responsible for completeness, accuracy, and delivery of the signed closing statement. If the closing docs and closing statements are prepared and closed by the broker is responsible for the accuracy. And if you're having someone else do it for you, you're still responsible for the accuracy and completeness of the closing statements at the closing table. You must deliver closing statements to the brokerage firm immediately following closing. Now, this doesn't have like a time, like this is immediately reasonable, like that's what this looks like. So as we're going through, you could see a test question on here, and it's just immediately. There's no like days or time attached to this thing. It's just immediately. A broker must deliver duplicates. So guys, if you're getting any paperwork signed, you must deliver duplicates out to everyone. Like everyone must get a copy of anything that you have them sign. And if we're going through, if the commission reaches out and says, hey, we're investigating you or we're auditing you, they're going to give you a time to when you have to respond in writing back to them and comply with their request. Now, if you don't comply within the terms and the time frame, then there's going to be some disciplinary action, like you could lose your license. There could be some fees associated with, like some stuff could happen. So you must reply in writing to any of the inquiries that the commission has for you. Going through in here, according to the position, unlicensed assistants may do the following. They may not negotiate, list, or sell real property. They may not prepare legal documents such as listing and sales contracts. They may not offer opinions, advice, or interpretations, and they may not disseminate or distribute information on listed properties other than prepared by the employing broker or salesperson. So if you get a test question, they can't do any of this. But what they can do is they can sit on an open house for you as long as they have permission from the seller. So this is what an unlicensed person assistant cannot do. I think the test question is probably going to have like 3 of these in there, but it's going to say, what can they do? They can't do these, but they can sit on an open house if they have permission from the seller. And there it is. They can provide access to a property and conduct showings or open houses. Now, sign crossing is important. So as we're going through and we're thinking about sign crossing, brokers will not negotiate listing directly with a consumer for compensation from said consumer if the broker knows the consumer has an unexpired listing contract with another brokerage firm granting them an exclusive contract. So I can't pick up my phone, or if I see a sign, I can't go walk past the sign and go door knock and say, hey, I seen this house has been for sale for a while. And obviously that agent that has the listing isn't doing their job. Would you like to list with me? That's against the law. That's how you lose your license. That's called sign crossing. Now, with that being said, if a consumer calls you and says, hey, I want to talk, my agent isn't getting it done, you can sit down and negotiate what it looks like for you to take over the listing contract when theirs ends. All right. So if they have a contract that ends in 3 days, you can sit down today and talk about what your new contract's going to look like in 3 days when the other one expires. That's perfectly legal. All right. So that was it, everyone. Like, as we're going through and we're thinking about the state test, there's 74 questions. There's 45 questions tied up into those 3 topics. And I promise you, like, if you get a good understanding around those 3 topics and you kind of know how they flow as you're going through and reading the questions, like, you are going to set yourself up for success. 43 or 45 questions out of those 74 are around Colorado contracts and forms, brokerage relationships, and activities of the licensee. The rest of them kind of fall into play. Yeah, there's a couple math questions, maybe on the state exam, but that is truly a lot of the different pieces that you should be focusing on, and they will help you with everything else. That is the PSI Real Estate Exam prep for the state of Colorado. Stay tuned next week for another new video to help you pass your PSI Real Estate Exam to become a licensed real estate agent.